Welcome back to Empire Law. I'm Abby, and today I'm here with Deborah Song from Empire Law. Good to have you back, Deborah. Thanks for being here.
Hey, thanks for having me back. Glad to be here.
Yeah, today we are getting into something that can make or break a car accident case here in Inland Empire, the evidence. Most people in Riverside County and San Bernardino County think of the police report as just paperwork, but according to the Insurance Institute for Highway Safety, there are over 6 million police reported crashes in the United States every year. And the quality of that report and the evidence backing it up often decide whether someone gets compensation or walks away with nothing. We are going to break down every type of evidence that matters: the police report, photographs, witness statements, video footage, medical records, expert testimony, accident reconstruction, and how it all comes together in a California civil case. If you have been in a crash anywhere from the 91 in Corona to the 215 in San Bernardino, this episode is for you. So, getting into question one, let's start with the document that anchors almost every car accident case in the Inland Empire. Why is the police accident report often one of the most important documents in a car accident claim?
It's the closest thing we have to an official, unbiased snapshot of the immediate aftermath. So insurance adjusters, they're not at the scene. Neither are lawyers like us. So the adjusters rely heavily on this document because it's generated by a neutral law enforcement officer, and it sets the baseline for the entire claims process. It shapes who the insurance company blames before any lawsuits are even filed.
Most people have never actually read a police accident report before their own crash. What information is typically included in a police accident report that can affect a compensation claim?
The police report acts as evidence. It's like a blueprint to any kind of case. It contains things like the date, the time, the precise location, the weather conditions. Sometimes it includes the diagram of the crash and statements from both drivers, and then contact information for any independent witnesses. And then it'll also have sometimes a notation for any visible injuries and if there was any property damage. And out of all of the details that you can find in the police report, one of the most important things that are identified in the police report often includes the officer's assessment of who is at fault and whether any California Vehicle Code citations were issued to anybody.
So the report is filed and the insurance company gets a copy. This is where a lot of people lose control of their claim without realizing it. How do insurance companies use police reports when evaluating car accident claims?
Insurance adjusters use them as either a shield or a sword. So they'll obviously use it to the best of their advantage, whatever's going to pay out less on behalf of the insurance company. But if the report says you were at fault, they will use it to deny or drastically minimize your claim. If it points to the other party, we use it to push for a fair settlement. But there are situations where adjusters treat police reports like gospel truth, even if the officer made a mistake or only heard one side of the story.
So here's something people argue about constantly. The responding officer writes down their opinion about who caused the crash and sometimes issues a citation right there. Can a police officer's opinion about who was at fault influence a car accident lawsuit?
Yes. In the insurance phase, absolutely. It heavily influences their settlement offers, but there's a little secret most people don't know. And that's traffic accident reports are generally admissible hearsay in a California civil court trial. So a jury, the 12 jury, if your case makes it all the way to trial, they don't just get to read the officer's opinion on a piece of paper that the police report is made on. The officer has to be called to testify personally about what they physically saw, but their ultimate opinion on fault doesn't automatically dictate a lawsuit's outcome.
All right, thank you. We have covered why the police report is so critical here in the Inland Empire. what's in it, how insurance companies use it, and what the officer's fault opinion really means under California law. But the police report is just the starting point. So now let's talk about the evidence you gather yourself, the photos, the witnesses, the video. So the officer is human, documenting a chaotic scene, sometimes in the dark or the rain or on 215, and sometimes errors happen. So what should drivers do if they notice an error in the police accident report?
You have to act quickly, but also understand that changing a report is very difficult. If it's something like a simple factual error, such as a misspelled name or the insurance information is incorrect, the police department will usually issue an amendment pretty easily. But if it's a narrative error, meaning things like the CHP officer, let's say the CHP officer arrived late, or they only wrote down one driver's story and not the other driver's story, you can't just ask them to cross it out or replace it or add it in. We have to submit a formal supplement statement. And then we also have to back that statement up by evidence, by, let's say, medical records or dashcam footage, something on top of the additional statement for the official police report to be amended.
And your phone is in your pocket and the scene is right in front of you. So most people take a few photos, but miss the ones that actually matter. How important are photographs from the accident scene when building a compensation case?
Photos are very important because, like you said, police officers are things of that nature. It's undeniable picture of a high impact crash. So even though a police officer might think, oh, I've seen worse, this is just moderate. Depending on the photos, the adjusters and us, we can be the ones to determine what the jury will ultimately think the damage is, whether if it is characterized as minor, moderate, or severe. Also, things like photos of skid marks, traffic signals, property damage, immediate physical bruising, things like that. It's very good to preserve the reality of the situation before the vehicles are towed away, and then also before the physical wounds are healed.
Photos capture the aftermath, but witnesses capture what actually happened. So why do witness statements often play a major role in proving liability in car accident lawsuits?
It has everything to do with something called credibility, because drivers inherently, they lie or they misremember details due to the shock that they're in. Like, I have a client right now that we are going into a deposition and we have to have her remember how the accident happened. And she swears that her car spun 360. And it's very possible for her to feel that way because she also suffered a brain injury. So even though the external world may have seemed like it was spinning at the time, if you actually look at the footage, you can see that the car did not spin. So there are situations, it's not because they're trying to lie or they're trying to make the situation exaggerative or worse than it actually is. It's just people have different perceptions of how things happen based off their own memory. So things like insurance companies, if it's a he said, she said situation, they will always back their own insured driver. They will never lean towards you because they have a duty to protect their own insurance company and their own clients and customers. So if there's a 50-50 chance, they're just going to side with their own customers. And same thing with our own clients' insurance companies. They'll do the same thing. So when you have an independent witness, someone who was just waiting for the bus or somebody who was driving behind you and has no financial stake in the case, that shatters any kind of statement the other side could make to make your case not as strong. So when you have somebody on the outside that has nothing to do with the case, they have no reason to lie. And so whatever they say holds a lot of weight to a claim as far as who is at fault, what happened. Their neutral account gives the case immediate credibility.
We are in an era where cameras are everywhere, dash cams, traffic cameras, business surveillance, doorbell cameras. So how can video evidence like dash cams or surveillance footage impact accident claims?
Video footage is very different than the human recollection. It's video footage, they don't blink, and video footage, they don't forget. We do. So if you have dash cam footage or surveillance video from a local Inland Empire business, that can entirely flip a liability dispute. Because prior to then, it's just he said, she said. If the other driver claims they had a green light, but a nearby store's security camera shows that they blew a red light, the insurance company's defense completely collapses. The catch, though, is urgency. The businesses, they overwrite their footage every few days because they have a limited space in their memory card and their SD card. They can't just hold on to footage until infinity and beyond. Some of our cases go up to like upwards of 5 years, depending on how intense the case may be. And the video footage is not going to just be there sitting in their SD card for the next 5 years. So every few days, their footage is overwritten. So we have to send what's called an evidence preservation letter immediately.
Yeah, we have covered what happened at the scene. So now let's talk about what happened to the person. What role does medical evidence play in proving injuries in a car accident case?
In a personal injury case, you can't just say you were hurt. I believe you, I believe our clients, but the other side is not just going to take your word or my word for it. You have to prove it through an unyielding paper trail. If an officer writes, no injuries, were in shock and the adrenaline hit your pain at the time, but you don't have any follow-up medical records within a reasonable time frame thereafter stating otherwise, the insurance company, like I was saying earlier, the police report is like their holy grail. That's like the insurance company's Bible. So if it says no injuries, unless there's contradicting evidence that is a higher level of evidence than the police report, you have no injuries. So if you have pain, and even if you said no injuries to the police officer or maybe even the insurance adjusters, because sometimes, when you make a claim, that's one of the first things they ask you, and you most likely made the claim that day, and maybe you still have the adrenaline and the shock and you're not in pain. So it's possible you told your own insurance company or the other side's insurance company that you have no pain. Then at least once you start feeling anything, you better go to the ER or a trauma center, urgent care, somewhere the next day or whenever the symptoms arise to correct that narrative. Everything is about paper trails. Everything is about evidence, medical records, diagnostic imaging like x-rays, MRIs, doctor's note, anything that links the physical trauma directly to the mechanism of the crash.
So photos, witnesses, video, medical records, those are all the building blocks. Now let's talk about the heavyweight evidence, the experts, reconstruction, and technical analysis. So expert witnesses are not people who saw the accident. They are professionals brought in to analyze the evidence and explain what it means to a jury. How do lawyers use expert witnesses to strengthen accident compensation cases?
We use experts to translate complex data into clear, undeniable truths for a jury or an insurance adjuster. Most of the time it's for the jury, because if we went to expert discovery world, that means we're within a couple months to trial. So most likely it's for the jury. The insurance adjusters, though, they do look at the testimony that the experts give during the deposition to see if the case is now stronger or weaker after the deposition. If the insurance company claims, for example, this is the one that we get a lot, is they don't usually argue that they're not at fault. We get that a lot from clients. They're like, I don't understand. Why won't they pay? I was rear-ended. It's a slam dunk. But it's not that they're arguing that they're not at fault. They're arguing that the injuries that you are claiming that you sustained from the accident could not have been caused by a low speed impact. So if your vehicle is minorly damaged, it's not too bad. Let's say it's less than $5,000 or $10,000 worth of vehicle repairs, they will probably consider that as a low speed impact. If it's just like a bumper replacement, fender bender, things of that situation where there's no airbag deployment, no windows have been shattered, no flattening of the hood or flattening of the trunk or things of that nature. If the car was repaired reasonably quickly, that's usually where their fight is. And so in that situation, we bring in what's called a biomechanical engineer. And these experts, these biomechanical engineers, their studies, their expertise, and their job is to explain to the jury or the insurance adjuster or the other attorney, whatever the situation is, their job is to explain how the exact G forces, that's what it's called, the G forces apply to your spine, and how that accident and the G forces from the accident caused, let's say, a disc herniation. So they provide the scientific muscle that insurance companies can't easily just dismiss.
Then accident reconstruction is the gold standard of crash analysis, the science behind serious cases. So how does accident reconstruction help prove what really happened in serious cases?
Accident reconstructionists are essentially like forensic scientists for car crashes. They take data from the vehicle's black box. The formal word for it is ER data. It comes from the black box of every vehicle. And the data that comes out of this black box are going to be things like analyzing the vehicle crush patterns. They measure the accident reconstructionists, even after pulling the data, the other thing they'll do is measure any skid marks at the scene. And then they'll use what's called their 3D modeling software that they have to recreate the physics of the collision. So if you don't have dash cam footage and you don't have surveillance camera, the next best thing that you have is you can hire somebody to create an animation to show the jury exactly how the accident happened. And these kinds of things prove things like speed, braking times, visibility, which can completely strip away the other driver's excuses.
And then the damage on the vehicles tells its own story. So how can vehicle damage reports help determine who caused the accident?
This is the evidence that we go through when we first get a client on the phone or in person and they want to tell us what happened. During that phone call or that initial consultation, we don't have time to hire an accident reconstructionist. We don't even have the proper information. So typically in situations like that, I will pull up the Google Maps, find out what intersection they're at or what freeway they're on. And then I will also look at the photos of all the cars involved and where all the damage was done. Because even with just that limited information, it can leave clues in the metal that explain the physics of how the accident happened. For example, the angle of the impact, the depth of the crush, and the transfer of the paint, even things like that tell a story. For instance, a vehicle damage report, they can prove whether a car was hit squarely from behind, or if it was sideswiped, or if it was hit from the left corner or the right corner. And depending on where the other car was damaged as well, I can understand, okay, this is what the story looks like. Because sometimes clients say that they're rear-ended, and then I see a non-rear end type impact, then I'm like, okay, there must be more to this story. And it's not that clients aren't trying to be truthful. It's just they only tell us what they feel that is important. And of course, we as lawyers, we have to look at it and the other side's perspective too, to make sure that we are closing any loopholes and we're making sure that the other side can't poke any holes. So the best way to do that is close the holes ourselves first and make sure we have an explanation for all these things that may not look like what they initially claimed to be. But yeah, so situations like that, photos, it can also help establish whether a driver was improperly changing lanes or failed to stop in time.
When the responding officer issues a citation at the scene, like a speeding ticket, failure to yield, running a red light, that citation becomes part of the evidence file. Do traffic violations documented at the scene strengthen a compensation claim?
Immensely. Under California law, we have a concept called negligence per se. It's a fancy Latin term, but negligence per se. PERSE. If a driver violates a safety statute that's written out in the California Vehicle Code under California law, something like speeding, driving under the influence, or running a stop sign, and that violation is what caused your accident, the law presumes that they were negligent. So instead of us having to prove by, let's say it takes 5 steps to normally prove that the other side breached their duty owed to you as a reasonable, prudent driver on the road. If the officer cites the other person, or they don't even have to cite it, most of the times the police officer won't actually give them a citation. But on page 2 of the police report, on the top left-hand corner, it'll show which party is the one that was at fault for the accident. And then on the right of that, it'll explain which vehicle code they were in violation of. And then on the right of that, the police officer will write whether the party was cited or not. Most of the times they're not cited unless it's something really bad, but at least you have that they're at fault and they are in violation of a vehicle code. So once you have that, you don't have to prove by 4 more steps, let's say, and explain your way as to why the other side is at fault. Once the officer says they violated this code, once you can prove that they violated this code, they are at fault. So it helps a lot as far as the leverage on our hands to negotiate settlement.
We talked about medical evidence proving what those injuries cost. So what role do medical bills and treatment records play in determining compensation amounts?
They establish the concrete baseline of what's called your economic damages. So when you have a claim against another driver for negligence or negligence per se, and you are trying to receive compensation, there's 2 different kinds of compensation, technically 3, but most of the time just 2 different kinds of compensations you can ask for. Number 1 is the economic damages, and number 2 is the non-economic damages. The economic damages are things that you can whip out a calculator and punch in numbers and calculate fairly easily. For example, things like medical bills, they will have a number on a bill. You can punch those in, add those up to come up with the economic damages. And then also, if you have any lost wages, if you've lost income, sometimes this can be a little speculative if you're like self-employed and you just started your business, things of that nature. But if you, let's say, are a W-2 employee or you have a well-established business where you filed taxes on and you can show proof of income prior to the accident for a good extended period of time, you can utilize that alongside with any doctor's note, off work doctor's note, any work that you had to miss due to attending a medical appointment, for example, or having to recover after a procedure, for example. You can utilize those pay stubs and those prior tax documents to prove how much you have missed out on, or any PTO, pay time off, or sick pay that you've had to utilize. Those, even though that you got paid under the sick pay and paid time off, you're still entitled to that. So that's also economic damages. Property damage, if you get an estimate or a repair bill from an auto collision center, that's something you can just punch up and calculate. Rental reimbursement, that's also something you get a rental, you get a receipt. It's very clear how much to calculate. Those are all economic damages. And then the number two is the non-economic damages. And those are things like pain, suffering, where you don't have a number of how much does it cost to walk with a limp every day? How much does it cost to not be able to pick up your grandkid? Things of that nature. But these medical records, they do provide and establish that concrete baseline for your economic, the first one. And they do more than show what you are owed today. So they do more than show just what medical bills you've incurred up until this point. They also help us to project future costs, because we can also ask the insurance company to pay for your future costs, even though they're not incurred yet, if that makes sense. So your treatment records, usually if the doctors are good and they're not doing chicken scratch, they will usually show on their medical records that, let's say, for example, you need ongoing physical therapy, you need future spinal surgery, things of that nature. A really good doctor will even write down how much that's going to cost you, and that's great for us. It makes it easier for us. If not, we have to look it up and see what the average cost is, and we'll ask for those compensation for your lifetime medical needs, not just your past bills.
We have covered the full evidence toolkit, police reports about how it all comes together here in the Inland Empire, how lawyers build a case, how insurers fight back, and what makes the difference between settling fast and going to trial. So building a car accident case is not about having one perfect piece of evidence. It is about layering multiple types until the picture is undeniable. So how do lawyers combine multiple types of evidence to build a strong accident lawsuit?
We look at evidence like a chain. A single link, so a single piece of evidence, might be weak on its own by itself, but when you build a corroboration chain, it becomes unbreakable. So we take things like the police report, then we layer it with scene photos, we lock it in with video footage, back it up with an independent witness statement. If you have all that's great. Usually when clients come, they don't have all that information. But the more information we have, the more chains we create, and the more chains we have, the stronger the link is. And ultimately, we anchor all of that with medical records. When the insurance adjuster sees a seamless evidence matrix, they realize they can't win at trial, which ultimately means faster settlement and, if the case goes.
We started this episode on why the police report matters so much, but what happens when the report is weak, incomplete, or flat out wrong? So can a weak police report be overcome with stronger independent evidence?
Absolutely. We were talking about it earlier. Police officers are humans. They make mistakes. Sometimes they arrive late, or there's other situations where they're misled by dishonest drivers. It's even worse sometimes when we have clients who their first language isn't English, and so they have a difficulty understanding our client's version of how it happened. And so ultimately they're like, you know what, I understand the other guy better. His story makes sense because I don't understand what this lady or this other guy is saying. Then ultimately the police report may come back not in your favor. But we routinely overcome bad or unfavorable police reports by uncovering other pieces of evidence. Just like we said, a police report is just one link of the evidence chain. If that link is no good and breaks away, you still have the other ones that we can use. For example, the Ring doorbell footage from a nearby house, or black box data from the other cars, or witnesses who left the scene before the police arrived. Sometimes there are situations where there are witnesses, but they can't stay and wait for the police to come 1 or 2 hours later. They got work to do. They got people to pick up, kids to take care of. So they will leave their contact information. Usually they'll leave it with the person who they think is not at fault because they trust that person to keep their information. But yes, there's lots of times where the police officers, they put incorrect information in the police report, but that's not it. As long as you have other information, there's other information out there to get that we can collect and we can use to prove your case. It's not the be all end all. So you should still be okay.
The insurance company is not going to look at your evidence and just agree. They have an entire defense playbook. So how do insurance companies challenge evidence presented by accident victims?
I call it the triple D when it comes to the insurance companies. Their goal in life is always to delay, deny, and defend themselves. So they will look at, even if we have good medical records, and sometimes I'll have even my staff, they'll come to me and they'll be like, oh my gosh, we got this letter, they're denying the claim, what do we do? I'm like, I don't care, that's what they do. They just deny claims. That just means we have to push and we'll move forward with litigation. But they'll even look at medical records, and even though it says it's related to the car accident, or it is clearly, it happened right after the car accident, and there is a, let's say, a evidence chain, a corroboration chain that shows, okay, they went to this doctor first, this doctor sent them to this doctor, told them to do this, they did that and followed up and blah, 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 blah. And there's a really good connection and causal chain and corroboration chain. They'll still look at that and they'll say, you must have a pre-existing condition. So they will use our own law. In California, we have what's called, I think we talked about this in another previous podcast, but in California, we have what's called a pure comparative negligence system. And they will utilize that to their advantage to argue that if their own driver caused the crash, our client was also 30 or 40% at fault, or our client's injuries were 30 or 40% created by something else prior to the accident, and therefore they will reduce the payout. How they come up with the number, I don't know, beats me, but they'll come up with a number and they will do whatever they can to defend themselves and to deny and minimize your claim as much as possible. The only way to go around that is to litigate the case. And whenever there's a way, they will create doubt. Every single time there's a single gap of time or evidence, they create their own links and they will connect that into your chain and create doubt for the jury.
Not every car accident case goes to trial. In fact, most do not. Why do some cases settle quickly when strong evidence is available?
So even though insurance companies love to deny and defend their own companies and to make sure they delay payment, at the end of the day, it's all about risk. Whether if it's health insurance, life insurance, car insurance, home insurance, whatever insurance you buy, they are calculating how much risk they have by signing you up as a client, by signing your car up as being under their policy, by signing up, is your house in a fire zone? Is your driving history tainted? Do you have a prior rap sheet of a DUI? Do you have things in your records that make it so that you are more prone to injury? For example, for life insurance too, are you the type of person that's been bungee jumping, skydiving within the last 30 weeks, something like that? And so ultimately, they want to make sure that they are weighing their risks, and that even goes to when it comes to resolving claims. They don't want to risk taking the case to trial if it means they have a chance of being hit with a high judgment. I think both sides, it plays out. I think as a lawyer, This is something that I struggle with sometimes because I know how much my client's case is worth, but emotionally and mentally, it's not in their best interest all the time to go through the whole trial process, sit there for 1 week, testify in front of 12 jurors. And even if it means they have a higher chance of getting a higher settlement or a higher judgment, a higher award from the jury, because they're also taking the risk of losing it all. So same thing with the insurance company. They have a chance of losing it all instead of giving a higher settlement offer now. So it's not only are they risking that, but to get to that point, just like we were talking about earlier with the whole expert testimony, expert depositions, when it comes to the expert world and hiring the accident reconstructionists and biomechanical experts and the biomechanical engineers and testifying and deposing all these doctors, these expert doctors, they're expensive. Easily tens of thousands of dollars, depending on how complex the situation is. I've even had a case where I had to flush out $200,000 on a case. So if I'm flushing that out, that means the other side is also putting in that money. So now there's $400,000 out. So not only are they risking paying out a higher award on top of what they've already paid out, but now they also have to think about, before we incur all those experts' costs, whether if they want to just create a little higher settlement to save on those costs just to settle the claim so they don't have to cough up more expense on their own end. So if we hand them an airtight evidence package early on with showing that the liability is clear, that there's undeniable medical proof, sometimes if there's expert backing, most likely early on we don't have expert backing, but they will realize that fighting the claim will only result in a massive jury verdict against them. So that's usually how they choose and determine to settle the case quickly and to cut their losses before they incur more.
On the other side of the spectrum, some cases have evidence pointing in both directions. When evidence is disputed, how does that affect the likelihood of a trial?
If there's a major dispute over who caused the crash or how severe the injuries are, the likelihood of trial increases. So the less evidence is equal to an increase of the likelihood of trial. If the evidence is 50-50, the insurance company will most likely gamble on a jury because it could go either way. And same thing for us, that's what we're thinking too. If the case is 50-50 because our evidence chain is missing half the links, then we are taking a big risk. It's flipping a coin, essentially, at that point. And at that point, the only thing I can really grasp and increase that likelihood by 1%, so 51, which is all you need to win a case in front of a jury. The only thing that really changes it for me to pushing it to that 51 of likelihood of winning as opposed to 49 or 50 or staying in the middle is really the client, how they present in their deposition, if they're likable people, if they are credible, if it seems like the jury of the peers, the jury of the neighborhood will believe what they have to say over the other person. For example, let's say I take the deposition of the other driver during the litigation process and I realize that the other driver presents very rude, very much a jerk, very much like their story keeps changing or they get very defensive, then it makes me feel stronger that the jury will like our client over them. So ultimately, that's what it comes down to if it's 50-50. Are they going to like your client or the other insurance company's client? And the other side will gamble on that as well. So our job throughout the entire litigation process is to use depositions, expert analysis, to destroy it in other ways systematically. And each time, I think of each little process during the litigation process, every little piece of evidence, every little nugget as it unfolds is like a battle. And so every time we win a battle or we lose a battle, that increases and decreases our likelihood at trial. And ultimately, by the time it gets to the point of trial, it will tell me, okay, we probably need to settle this case, or let's take it. I think we got it. I think we should be good. So we can still systematically destroy their disputed points in other ways until the trial becomes too risky for them to attempt it.
Deborah, last question before we wrap up, and it is the one everyone wants the answer to. Out of all of it, some evidence carries more weight than the rest. So what are the most powerful pieces of evidence that tend to win car accident lawsuits?
Objective is the key word. Anything that is evidence outside of your mouth, outside of my mouth, anything that can show an unalterable way of winning the case always wins. So high quality video footage of the actual impact is incredibly powerful. I always tell my clients, please get Dashcam footage. It's not going to help you this time, but if God forbid something happens in the future, it'll protect you then. Close behind that are going to be statements from truly neutral third-party eyewitnesses. And I say truly neutral because sometimes clients come in being like, oh yeah, my daughter was driving right behind me. She saw everything. But at the end of the day, she's your daughter. So she's going to say things, even though it might not be true and she might be telling the truth, the jury is not going to put as much weight to that than Billy Bob Joe that happens to be driving in the same direction as you. And then what else? We have objective medical imaging, like an MRI showing fresh physical trauma to your spine or extremity, shoulders, joints. And then when you combine all of that, the video, the neutral witness, clear medical proof, it's almost impossible for the insurance company to defeat your claim.
And that combination point is critical. It's never just one thing. It is everything working together to tell the same story. Deborah, that's an incredible breakdown. For someone watching this who has been in a car accident and is trying to figure out whether they have a strong case, what is the one thing you want them to remember about evidence?
One thing to remember is document everything, and it's really hard to do at that time. And I think it'll only work if you constantly remind yourself every day. Maybe it'll help if you have like a checklist based off of this podcast, a list of things for you to jot down, and police, like the police, photos, videos, evidence, bruises, things of that nature. If you just make a checklist and keep it in your glove compartment, because ultimately when you get into an accident, you're going to reach into your glove compartment for your registrations, not your license, but your registrations, your insurance information. And so when you pull that out, if you have that checklist, just make sure to go through that checklist. So you don't have to think about memorizing everything that you have to do, because in that situation, you're in a high shock, high adrenaline, you're not going to remember. So if it's there, you can just kind of check it off and make sure you do it all before you leave the scene.
That is great advice. If you have been in a car accident in the Inland Empire and you are not sure whether your evidence is strong enough to pursue a claim, make that call. You can find Empire Law at www.inlandinjury.com or call them directly at 951-724-5307. Thanks for watching, and we will see you on the next episode of Empire Law.